So today we're talking about antitrust laws and what employers need to know about the Sherman Act. And this is something that small businesses may not think has anything to do with them, but it actually comes down to very small businesses, franchisors, franchisees, um, staffing agencies. It really affects both small and large employers. And you need to have information on the Sherman Act and antitrust laws to make sure that you're not violating any laws. So this is Michael Johnson. This is not me, but we have the photo here. So just a quick disclaimer, this presentation is for educational purposes only. It is not legal advice and does not create an attorney-client relationship. We'll let you know, as Dan let you know, on how to contact us if you have specific questions. So today's agenda: what is the Sherman Act, potential pitfalls for employers, and how to comply. So what is the Sherman Antitrust Act? So the Sherman Antitrust Act was passed by Congress in 1890. So previous to that, several states had passed similar laws, but they were limited to intra-state business. The Sherman Antitrust Law was based on the constitutional power of Congress to regulate interstate commerce. So now the law prohibits you from engaging in antitrust violations both in your state and including engaging business anywhere across the U.S. So claiming that you are not in the same labor market as others in the same industry because of geographical distance is not going to help you when it comes to the Sherman Act. This regulates interstate commerce, and so you cannot claim that you are in a small area and that it's okay to go ahead and do your own thing. A trust is an arrangement by which stockholders in several companies transfer their shares to a single set of trustees, and in return, the stockholders receive a certificate entitling them to a specific share of the consolidated earnings of the jointly managed companies. So this kind of fits with the new NLRB regulations on jointly managed companies. You can't have several companies together and have the stockholders all transfer their plans to their shares to a single set of trustees. So the Sherman Antitrust Act authorized the federal government to institute proceedings against trusts in order to dissolve them, and any combination in the form of trust or otherwise that was in restraint of trade or commerce among the several states or with foreign nation was declared illegal. So we will talk about that restraint of trade or commerce. So what was the goal of the Sherman Act? So these terms were initially unidentified until a series of court cases challenged the act. Can we move to the next slide, please? They were initially undefined until a series of court cases challenged the act. So the act had to be reformed to define these terms so that businesses knew what to watch out for. So President Theodore Roosevelt went on a trust busting campaign to see the act enforced with considerable success. And by 1911, this had been used against the Standard Oil Company and the American tobacco industry. In the late 1990s, to ensure a competitive free market system, the federal government used the Sherman Antitrust Act, which was then over 100 years old at that point, against the giant Microsoft computer software company. So it was still in effect as it was when it was first enacted. It's only grown stronger over time. And so now when you're in a time when highly skilled workers can basically write their own ticket, it is very tempting for employers to want to conspire with other employees employers to keep employees in place. When there's a lot of opportunity for mobility between companies, it's very tempting for the employers to want to get together with other employers and create like a wage ceiling, for example, or something like that. And tech companies are the most at risk here, both of being a monopoly and sharing perks and benefits with each other, but this really applies to all industries. So the benefits of antitrust law. Um, some of you may be thinking, how do I make my prices lower but pay my employees more? That's what antitrust laws have essentially been passed to do, even though this seems like another employer unfriendly employment law. Antitrust laws motivate employers to be competitive, to be the best, to keep thinking of more products and more services, to attract business and make their customers happy. Higher wages and better benefits for employees reduces retention problems, especially in industries where workers are in high demand. Your competitions will be facing more turnover, which is expensive. Recruiting, onboarding, training, all a part of turnover that you don't want to have, are going to make for happy customers. So more choices and lower prices for consumers can also sound like a punishment, but if you establish yourself as the smart choice, both financially and quality-wise, you will attract more business. So competition is a good thing, particularly for small businesses, because you can offer an alternative to the big brand name companies, which is going to inspire loyalty. And the more disposable income customers save and the higher wages to your employees, that all gets put back into the economy, which makes your business more attractive to people who were previously skipping your service as a way to make money. So what you can't do under the Sherman Act, you cannot form an agreement not to hire a competitor's employees. You cannot discuss wages and benefits with competitors. You cannot communicate your company policies to competitors, and you cannot enter into agreements with others in your industry regarding terms and conditions of employment. So that is essentially what you can't do under the Sherman Act. What you can do is you can make independent decisions on hiring, firing, soliciting, recruiting, and setting wages and benefits. Now, if you're doing that all on your own, making independent decisions, that is fine under the Sherman Act. You just cannot do it with information you learn from a competitor or make an agreement with the competitor about how you are going to accomplish that. Your decision just has to be independent. Illegal activity and prohibited activity, naked, no poaching, and wage fixing agreements are per se illegal. If you join up with another person or another company in your industry and say, we're not going to poach, we're not going to fix wages, that's per se illegal, and oral arguments are considered the same as written arguments. A flat out agreement between two businesses not to raise wages or hire the other's employees are flat out wrong and will result in civil and criminal penalties. Back in the 1800s, the penalty could be up to a $5,000 fine and a year in jail. Those penalties have increased with time. So case law, even though it was between franchisees and the overarching business is the franchisor, franchisees still couldn't form antitrust alliances between each other. franchisees are considered competing employers. You cannot get together with other franchisees at a conference and discuss how much you pay employees, what your policies are, why you terminate employees, whether you agree to hire or not hire employees of another franchisees. Franchisees are considered separate businesses, and you cannot discuss this with other franchisees. So particularly of interest with the new joint employment rules, uh, you can see here with the Burger King case that the franchisees discussing their terms and conditions of employment was considered concerted activity under the Sherman Act. It was remanded to the district court and now awaits a class action. So this is going to be a very large amount of money for a number of Burger King franchisees who got together and talked about their wages and talked about their terms and conditions of employment to create kind of a wage ceiling to keep employees from transferring from one to the other. Particularly of interest with the new joint employment rules, staffing companies may be considered joint employees with the client. So staffing companies cannot make agreements with other staffing agencies not to send temps to a certain client, but now the client can't talk about wages or benefits with other clients or agree with other clients not to hire your temps. So you need to watch out for that if you're in the staffing agency. Compliant exceptions. A neutral third party is not someone you find who doesn't directly work in your field, but you send them to gather information about your competitors and bring it back. A neutral third party would be a newspaper article stating that they had heard about Google's employee perks and reported on it. That would be something that would be a third party source if you saw an article like that in a magazine. Old information that is no longer at risk of influencing wage and benefits may be shared. You can talk about how you started your business and the process you used to get employees on board and increase and decide on an amount of wages back then. Just no talking about recruiting practices and wages in the here and now. Now, you must let your employees own wages and benefits between themselves and between other companies. If your employees find enough research on their issues industry-wide, they can present it to you as long as you are not taking in direct information about a direct competitor specifically and using that information. So it seems difficult. What do you talk about at an industry meeting? Well, not wages and benefits, products, marketing strategies, anything but terms and conditions of your employees' employment can be discussed. If you offer a gym membership to your employees as a perk, you can't talk about it because then all your competitors might start offering a gym membership as a perk as a way to steal your employees or teach your employees not to expect better from any employer. So perks like that, fringe benefits, you can talk about it. So overall, uh, antitrust seems very difficult, but the point is you just can't share information about your policies and procedures, terms and conditions of wages and benefits, um, and have no poaching or agree to not hire another employer's employees. Those are the things that you cannot do. And it does seem difficult, but you have a way around it because there are plenty of other things you can talk about at an industry meeting other than the wages and benefits of your employees. And just I hope that settles that the Sherman Act is not just the reason why Amazon can't buy up all the grocery stores and make us all shop at Whole Foods, which is most people think that antitrust laws are. They actually affect small and medium-sized businesses. They affect franchisees and joint employers. They affect staffing companies. The antitrust laws really affect all employers, no matter how big or how small, and can result in serious penalties for violations. So like Dan said, if you are one of our clients, please open up a ticket in our Ask system if you have further questions. If you are not a client, please email us at info@myhrcouncil.com. We can set up a demo for you and answer any questions that you may have about our service. So remember, compliance is not optional. Thank you all for participating in the webinar today. I hope you all enjoy the rest of your day.